A beautiful day in the neighborhood. A beautiful day in the neighborhood. A beautiful day. God bless America, land that I love. Hey, bro, you love America?
It's alright.
It sucks, don't it? Keep it real. It's fucked, isn't it?
The court system.
Can I put you on my YouTube?
Go ahead, man.
Hey, so, what's up? Did you just have court?
I did.
How'd they fuck you over today, bro?
Well, I mean, it was kind of my fault. I didn't.
Don't admit that on video, bro.
It's already done.
Oh,
yeah.
So you already went to?
Yeah.
All right.
I didn't have a license plate.
Right.
And I also didn't have insurance. But I mean, it was.
You familiar with the 14th Amendment right to travel?
Not really.
I'm just fucking with you, bro. I'm not a sovereign citizen. You got to follow those laws, bro.
Yeah.
You know what I mean?
Mm-hmm.
So they got you.
Yeah, they
you
got
fucked
me.
up, right? You're
up.
young. You know what I mean?
Yeah.
See, that's the point of the court system. You know what I mean? You fuck up, you go in there and you're like, damn, you fucked up.
Yep.
You get it, you know what I mean? And then you learn from that, right?
Exactly.
So it's like, see how they're looking for me?
Yeah.
You know why, right? My hat. You know what I mean? It might be my bow tie or it might be my stunning good looks, why cops follow me everywhere.
It's probably the good looks.
Anytime I come downtown, they follow me everywhere. I'm sure it's the stunning good looks. That's probably an undercover right there, but it's all good. And so, yeah, so you fucked up.
I fucked up.
You're gonna learn, right?
Probably not.
You're not gonna learn from it? Don't tell the judge that.
No, of course not.
I'm just fucking with you. Good work, man. Yep.
You make America great again.
Hey, I'm working on it one court hearing at a time. I'm gonna make America great one public meeting and lawsuit court hearing at a time. I just made that prosecutor great again. Hopefully he learns that you can't be, if you're gonna be the city prosecutor, you can't fuck around. And especially, you can't fuck with Lane Myers. Lane Myers. Hey, it's LANEMYERS. It's the Lane Myers because they were accusing me of maybe they were saying that I was hurting their feelings, so that might be threatening them. No, I'm threatening their ignorance, their incompetence, and their stupidity. But if you look it up, go to Lane Myers. It says Lane Myers channel for nonviolent social change. You can't punch your way out of problems. You know what I'm saying?
Yeah.
You gotta articulate your way out of the problems. Like, you know, Lane, LA, right? Lane Myers.
Oh, Myers, okay.
Lane Myers. There he is. Right there. Now you're gonna, now this will pop, hey, once I put this in, you know, it'll pop up on your thing saying.
Alrighty.
Well, I'd say I gave a lesson in, I think I examined the prosecutor, right? See, that's what happens. See, if the court, I shouldn't have to make videos examining the prosecutor on my YouTube. I shouldn't have to make videos examining the judge on my YouTube. I should be able to go to court, okay, and make my legal arguments in the proper forum, and we don't need to litigate this case on YouTube, do we? And get people's wives, and people this, and people that, and all that shit involved, do we? Huh? So, you play stupid games, you win stupid prizes. Yeah, I fucked up, talked a lot of shit, got somebody close to me. It'll all equal out in the end though, right? And so, you know, they want to play them games like, oh, hey, did you see how the prosecutor came in there and tried every dirty trick in the book and got shut down by this crazy MAGA terrorist school shooter idiot? Huh? Or maybe, just maybe, it's the overlay for the underplay. Ooh. Now how do I end this shit? Huh. I don't want to fuck it up. How do I end it? Man, now I gotta figure out how to end this shit safely. Hey, tell me in the comments how to end this video with it, like, without it deleting or something. There's like a thing, along the side with like a camera, a microphone, all this shit. There's a thing along the top that says.
To accept this call, press 0. To refuse, your current balance is $29.76. This call is subject to being recorded or monitored, except for communication between attorney and client. If you are an attorney or designated counsel, hang up and call the Pima County Jail at 520-351-8027. Three-way calls or call waiting is not allowed and may automatically disconnect this call. Did you know the person calling you now has voicemail? You can leave a message for this party by calling 520-448-3426. You will need to know the inmate's 9-digit phone ID. Thank you for using GTL.
Bro.
Yo.
You alive, bro?
I'm alive. You on? Can you hear me?
I can hear you. You're talking to the whole world.
Well, gotta be careful what we say.
Facts.
I got new charges for my last live stream out from jail.
So that's another 4 felonies?
Since the originals. Since the original 14, I got 4 more now, I guess, or more, who knows. They said I did 1 felony and get out this week.
They said what?
They said I could plead guilty to 1 felony and get out this week. As long as I take the videos down and apologize.
Did you tell them how that wasn't going to work out for you?
I didn't even talk to them about it yet. They just told me it. I didn't really get to talk more about it. But the thing is that, we can't talk about the case on YouTube right now because all it's doing is getting me more felonies, and every felony means I can't get out of jail.
All right.
Because I'm not allowed to get out of jail now unless I win that trial because I got charges while I was in jail.
Somehow.
Well, I got the grand jury. Hey, I put you on a list for Parvin to be allowed to communicate with you about public records and stuff. I signed something that he's allowed to talk about the case with you today.
Okay.
I got the grand jury testimony. Grand jury indictment transcript, whatever you want to call it.
Okay, I'll get with him.
And I want you to, that's what I'm saying, figure out if it's a public record or figure out if it's like something that you can, order or get from him or something like that.
All right.
I'm mostly worried about my wife because, she didn't sign up for this. Who would?
Yeah, no, you're right. Who would sign up for it other than you?
So I got my wife and my dog sitting there, and I'm the main provider. I put food on the table. You know what I mean? I pay the phones, do this shit, and now I'm sitting in here. Business credit cards and shit that got to get paid somehow from jail. That's not about the money. It's more about like logging into the app and shit on my phone. Obviously, I'm not making money if I'm in here. But, hey, so people were showing up at my house today.
At your house today, huh?
Mitch went to my house and thought he'd be funny and go live and talk to my neighbors. And then he pulled up at the cop shop smoking weed live. That's a good way to get yourself arrested. So this dude, literally, the one that I said was the main suspect, showed up at my neighbor's house asking them questions about what happened with my window. And then they all took pictures of him and turned him into the sheriff. And this dumbass drove up to the sheriff himself to ask the sheriff what happened. And immediately made himself the number 1 suspect.
Wow.
Which he was already the number 1. Remember who was the first suspect?
I do remember.
Oh, okay. So now I'm in jail and there's people going to my house to harass my wife. But they're not getting charged.
It's outrageous.
They're not even, my wife's just minding her. So what about going to my neighbor's houses? This guy went to my neighbor's houses? Are they public employees? So we could show up at people's private property and go up to their door and ask them questions, live on YouTube on their property without their permission? I've never done that.
I guess it just depends on who.
I've never went to somebody's house and started talking to their neighbors about an incident at their house. He doesn't realize that all he did was now put himself on all the cameras that saw the whole thing in the first place. That's how dumb these people are. They knew I was in jail, so they went to my house and started harassing my neighbors and my wife. YouTubing, zooming in on the window that we repaired and shit. Now, how is that, A, not against YouTube's policy, but how is that not an actual crime? Am I missing something here?
I don't think you're missing anything.
So somebody that I was already thinking was the main suspect based on the little silver car is now coming to my neighborhood from wherever, and the cops are like, so you drove down from wherever just to check it out, huh? That's the level of stupid we're dealing with here.
Jesus.
The dude drove into the police station parking lot smoking weed on a live stream, going to investigate my fake window story. That's how dumb these people are. They think that. So somebody came to our house, smashed our window out. There's he might not have talked to the neighbors that he should have. I don't know, but there's videos. The police, he just got. There's plenty of videos and eyewitness testimony and all that kind of shit. And they're saying I faked this shit. I'm sitting in jail. This guy's out harassing my wife, harassing my neighbors, and saying that I fabricated a story. But this guy's out there to do that while I'm sitting in here. And so how do you think that's making my wife feel? Obviously freaked out, right?
Yeah, that's a rational thing to feel, I would imagine.
But somehow I'm the menace to society.
Because of your YouTube.
Yep. I mean, they had to lie to the grand jury, so they're already starting off. They couldn't even get the grand jury to be 12-0. It's 10-2. So if the grand jury, they got to get the jury to be unanimous. How are you going to get a unanimous verdict when you couldn't even get the grand jury to be unanimous and you were allowed to lie to them? So you went to the grand jury where you're allowed to lie. I'm not there to question you or present evidence, and you couldn't even get 12-0, but you got 10-2. So then it's 10-2 without me being able to say anything. What's going to happen when I get to question everybody under oath as my own lawyer and give them the you know what I mean?
The full treatment, the experience.
The full deposition under oath.
Yeah, they should probably open their eyes a little bit.
So everybody that wants to testify against me, I'm going to get to question them under oath. They want me to plead guilty. I mean, my thing is like, don't people realize that if I plead guilty just to go back and save my relationship with my wife, then that's going to create a piece of paper that says they can charge everybody else because they found me guilty? I don't think people really understand. People like Mitch who's showing up at my house, he's going to actually be in jail, I won't. But, like, it's like, okay, so let me get this straight. Direct D says all that crazy shit, and he's not in jail yet? I'm in jail. They had to lie to the grand jury to get me in jail. But we have verified evidence of other crimes that they're letting go by. A guy was in here for choking his pregnant wife and beating her with a gun, and he already had 6 domestic violences, and he already bonded out.
Yeah.
Just think, I want the whole world to listen. I want the whole world to hear this. The Pima County Attorney's Office, Rachel Stiles, Laura Conover, think the world is a better place if a guy who has 6 domestic violences choked a pregnant woman and beat her with a gun and strangled her. He's out on bond for $1,000. He had $10,000, $1,000. I'm being held with no bond. But somehow the world's a safer place with a guy who beat a pregnant woman, pistol whipped a pregnant woman and choked her, who had already been previously convicted of 6 DVs. He's out there walking around right now on the street while I'm sitting here in jail talking to you. And this is supposed to be about justice? This is Laura's laws.
Yeah, it sounds pretty gross to me.
How is that not targeted retaliation? Have you got any charges yet?
I haven't gotten any charges yet.
Did the FBI show up yet?
The FBI hasn't shown up.
They haven't said, Mr. Gray, we need to talk to you?
I haven't said it.
Interesting. Have you gotten anything in the mail?
I haven't gotten anything in the mail yet. I'm checking twice a day. There's so much anticipation because, it's not just that, bro. It's not just that you're being charged for one thing, but, you do this to everybody. Where are the charges for everybody?
That's what we're going to bring up in trial. Right?
Well, trial, that's a long way away.
No, they got to have me at a trial within 6 months. Can the shareholders help my wife eat till then?
The shareholders can do this, yes.
That's the thing, because what people don't understand is I'm the test one. If they can convict me for my YouTube videos, they can convict anybody.
Yeah, well, ain't that the truth? Because if they can convict you, literally, they can convict anybody. If anybody is in a position to argue it, it's you.
Well, I'm not in a position to argue it now because I'm in jail. See, the plan was to argue it while being my own lawyer at home on Westlaw. But then they put me in here, and now I can't do anything. So they're going to try to force a lawyer on me and force me to plea bargain and all that shit, or they're going to give me some half-assed lawyer at trial and, not make the arguments I want to make because I don't have access to the material. Do you get what I'm trying to say here?
I do.
That's why people need to leave the people in the story alone. They need to get a hold of my state representative. They need to get a hold of Congressman, the FBI, the fucking Attorney General, the people above above Lord Conover. Not, every time somebody emails the devil, I get a charge.
So just to be clear, we want to be focusing all of our attention on the outside and no longer on the inside.
Right.
Yeah.
What I'm saying is that the judge knows, okay? Apparently there's people emailing the judge even after I took the thing down, okay? And so the judge is sick of hearing it. But, what is he going to do? Deny the truth? And so, is the judge going to hold it against me because people are emailing saying that I should not be in jail? I don't think so. I think this judge is fair. I think he knows what's going on already. Big time, definitely, you know what I mean?
I hear you.
How many people have the support I do when you know what I mean?
We talked about this last night, man. We talked about it.
There's not crazy people like Warren and other people like Mitch who show up at my house harassing these people actually, you know what I mean? People could be saying whatever, but the thing is we just got to drown them out with positivity.
Yeah, well, and I think that's what the shareholders have been bringing. They've been bringing they've been sending me the emails. So because
what I'm saying is what am I fighting for if I sit in here and fight this only to get out to have nothing left? My wife threw all my shit in the trash, divorced me, and sent my dog to the pound. And I get out of jail and I beat all the charges, and I'm standing on the sidewalk a free man with nothing. But I know I won't have nothing because I'll have myself.
That's true.
But it's like, okay, well, I like the life I have with her. And it's like, well, she doesn't want to be a part of this YouTube thing. You know what I mean? Never has, never did. It cost her her job. It cost her. But she is also a lawyer and can look at the law, right? But she also knows that these people are evil and can try anything because they have the power until they don't, right?
Yeah, and will use it.
You know, and so like I have recorded phone calls with federal agents that I'm going to play at trial. So let's do it. You know what I mean? I have recorded phone calls with federal agents telling me how my wife got fired. And it's, you know what I mean, going to come out at trial. Because because the FBI has been aware of every single thing in this case. Every single email I've sent Rachel, the FBI is CC'd on. Every single thing they do to me, I just forward it to them, right? So they've known about what the prosecutor's been trying to do to me since the first day. I went up there live on my live stream and said, this is what's going on. They knew everything that was happening with the prosecutions at city court, for the booing, those people involved in that. So it's not like they can just snap their fingers, but you better believe there's a giant paper trail with them showing that I've been showing them what I'm doing because I know I'm not breaking the law, right? So every email I've sent Rachel, the U.S. Attorney, the FBI, the Attorney General, all the local newspapers, you know, a bunch of different people have all been on those. So every email I sent Rachel, the feds have already read. So it's like, well, they didn't come arrest me, did they?
No, they didn't.
Why was I able to make videos about the U.S. Marshals and not get arrested? Why was I able to go to the FBI live on a live stream and not get arrested? Why was I able to go and make videos about federal judges? Why was I able to make all these other videos and not get a charge, right? Now, we can just leave that for people to figure out, you know, that's kind of like food for thought because we don't need to discuss it. But in the end, it's like, Parvin's in here talking about, man, it's like, bro, yeah, I'll be in prison, I'll be a hero. Cool. It's not the life I want, but like, okay, so who's gonna carry the boats and the logs, right?
That's right, Lane.
But it's like, everything that I have built up to this point is on the line, you know?
Well, I feel like the shareholders can step up, man. I mean, I've been stepping up. I feel like some others have been stepping up. We got to rally around you, you know?
But the thing is, it's Rachel is, but she also knows I'm not going to plead guilty. She's like, what's the point of offering him a plea bargain? He's not going to take it. Why would I? I didn't break the law.
Exactly.
Why would I plead guilty to a felony, give up my right to an appeal when I didn't even break the law? So to me, I might be butt naked sleeping on the sidewalk homeless, right? And my dog, I never got to see my dog again. I've never been more than 3 days without my dog in 8 years, right? So he's probably going, where the fuck is he, right? That's what dogs do. They rely on their, right? So it's like he's looking around, and I'm thinking, and that's the shit, right? But then, am I cold-hearted? Am I a piece of shit because I say, you know what? You know what I mean? I got to do what I got to do. You see what I'm saying?
I do see what you're saying.
At some point, you got to look yourself in the mirror every day, though, and it's like, all right, well, I had all this great life, and I thought I was following the law, and now I'm sitting in jail, and people are showing up at my house, harassing my wife. Those are the real. It's like. I've never done that to anybody, but I'm facing 20 felonies. I've never done what Mitch did today to anybody in my life, and I'm sitting in jail on 20 felonies. But Mitch is out there harassing my wife and my neighbors. Really harassing my wife and neighbors, smoking weed on a live stream as they pull into the police station parking lot. And then the guy gets to beat it. So I just want the whole world to know that if I would have got my wife pregnant and choked her and beat her with a pistol, I'd be out right now.
Those are some messed up priorities in Pima County.
hear it. Bar complaints and Laura Conover type shit. Rachel, like, you know, the other people involved don't need, it doesn't matter. They know how, you know what I mean? That just gives them more things to hold against me. But Laura Conover, she's the problem. Why every Facebook post she makes should have hundreds of comments about me. Hundreds. Not 2 or 3. Hundreds. Every comment, every post on the Pima County Attorney Facebook, hundreds of comments about what's happening. 1 or 2, they can ignore that. You know what I mean? It's only like a little poke. You know what I mean? And so it's like, okay, well, I'm sitting in here. Now I can't even properly defend my case. I can't even get access to the legal stuff. They put new charges on me that I can't get access to this stuff to defend myself. And then I'm supposed to fight it, you know, not plead guilty or whatever. And because if I plead guilty, then they can just take that and convict everybody on YouTube.
Yeah, that's
what's
sick.
going to stop me? What happens if I lose everything, my wife, my dog, and everything, only to be found not guilty? See what I'm saying?
I do see what you're saying.
I have the grand jury testimony. I know what they're going to say in court. I'm not worried about being convicted by the jury. I'm not. I am not worried that the jury is going to find me guilty. And that might mean I'm crazy and I don't know what I'm talking about and I deserve everything that happens to me or whatever. But like, unless suddenly I don't know how to read the law for the last 300 years, were they going to come in there and say that I said something offensive? That's not a crime. Were they going to say I said something vulgar? That's not a crime. Were they going to say I said something, whatever, vulgar, offensive, whatever? I know they can't come in there and say that I threatened her. You get what I mean?
Yeah, I do get what you mean. They can't come in there and talk about a crime occurring.
They can't come in there and say, on this date, at this time, he threatened to do this. Because it didn't happen.
That's quite a mountain to climb.
How can they charge him with fear? How can they charge me with the crime where the person that's charged with it fears for their life, right? That's like the count, and that's what's in the grand jury. The grand jury is the one that made it fear for death or whatever, and they voted 10-2. So even them people didn't agree that I did enough to make the person that's involved fear for death. You know what I'm saying? So they went in there and they tried anything they could, and they couldn't get the grand jury to say 12-0. We believe. How are they going to pull 12 people off the street that I get to show evidence, put the witnesses on the stand, show recorded calls with the FBI agents where I fucking know what happened, okay? I know what happened. I know what happened with my wife because they told me. And so it's like, well, at the end of the day, I'm going to get this. So what are they going to do? Come in there and show my YouTube video? Okay, I'll get to talk about it. I'll get to say this is what this and that, right? If you read the grand jury, it's really weak. It's the weakest shit I've ever. I've been indicted by a 900-page indictment before, okay? By the feds. This is a fucking. Let me see. These people don't realize that I was indicted by the feds when I was 5.
The problem is you're already in the punishment phase.
I'm already getting, right, and I'll never get this time back, and I'll never get my wife and my time and my dogs and all that shit back, right? I'm already being punished for crimes I didn't commit.
Yep.
And that should be a huge wake-up call to people.
It really should be.
But what it really is the chance for fucking losers to come harass my wife at my house. Mitch, the YouTuber, went to my house and went up to my neighbors' houses and went asking them questions about the night in question. Imagine that. Imagine that shit happening to you. But I'm sitting in here being punished for crimes I haven't even been convicted of. But there's people out there committing real crimes, not even being charged. Oh God, imagine if the Direct Deed made a post saying that he hopes I die. He hopes I die in a violent car crash, burn, die, whatever, pass into the shadow realm, right? Imagine if I made that comment about the people in this situation.
Yeah, they might actually have some charges that could stick.
Now, if I said that, and they went in front of the jury and said, look, he made this whatever it is, a tweet that says, I hope, people die in a crash. Yes, I want to see him dead, and I want to see him pass in the shadow realm, all that shit, right? Now, that would be some psycho shit, right? The jury would be like, wow, that's crazy, right? And what I'm saying is if they want to put this in front of the jury, I'm here for it. Harvin is my lawyer in the new cases still. But in the first case, I still got the slap motion too. And to me, if the judge doesn't grant the slap motion, then the judge is not following the law.
That's kind of what I've been saying, man. I want to believe the judge is honorable, but come on, man.
All the other judges so far have not been.
Yeah, only Riojas, right?
Yeah, the only one that was honorable was the one that's been suspended for misconduct.
Sick irony there.
Guess who they got me for a judge tomorrow? They're bringing in a special judge just for Lane tomorrow. Guess what the key qualifications are?
A woman?
A woman, not an actual judge, one of those bring-in judges, U of A law school graduate, prosecutor.
Oh, that sounds great. What the fuck?
And then they're trying to say this ain't a rigged system.
Wow.
You see what I'm saying? I'm definitely not getting out tomorrow.
Yeah, that's what I've been telling everybody.
We might be able to get some action on Friday. The faster it gets back to the main judge, the better, right? So tomorrow I have this fucking stupid bond hearing where they're going to make a fool of me and play new charges and, you know what I mean, make me look really dumb so that they can hold me in jail, right? They're going to make me look, they're putting a woman U of A prosecutor as a temporary judge for the day for me. She's not going to let me out. It's going to go to the next phase of the state of this shit, right? So, at least I'm going to be in here for at least 20 days before I can get in front of a judge who has the power to actually grant me a bond.
Jesus.
Because I got to get back to my main judge, the one with the slap motion, okay?
Yeah.
So the thing is, the one with the slap motion, it knows what's going on already, right?
Yeah.
I have court tomorrow with the judge, the fucking fake, these fake these temporary judges they bring in just for lame lawyers.
Yeah, kind of like Walton.
They are bringing one of them. Right, Judge Weiland, not Walton. Walton's a judge. Weiland's Weiland's a lawyer who comes in when they need somebody to give you one. But my thing is, do these people have no shame? Because if they want to go to trial, I'm going to get to play the recordings on my YouTube channel of the court dates. But look, so tomorrow they're going to bring in this person, and they're going to say, oh, yeah, he's crazy, keep him in jail. Not crazy, but you know what I mean. I'm definitely not crazy like that. They're never going to be able to find me, like, crazy, because I'm not. And so they're going to come in there and say, oh, yeah, he's a bad guy, he whatever, blah, 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 right? Harvin's going to get to argue. We'll see, right? But then on Friday, I have another court date. Back with my judge with the slap motion, right?
Yeah.
Where Rachel's trying to get my bond revoked on that one for the same videos that I'm being charged with, okay? So she's asking the judge with the slap motion to say that those videos are a violation of bond, so I should revoke the bond on the 14 charges. And she's saying to the grand jury, those are also new charges. To me, I think the judge on Friday is going to say that the video that they're most mad about is the silent video. Harvin said that's the one that they're the most mad about. The silent video.
Jesus. Crazy, bro.
That's the one Rachel. So the video that Rachel's going to make a big deal about tomorrow is the silent video. They're going to say that I made a silent video, which is telling people to harass somebody.
I hope they turn the volume all the way up.
But that's my point, is that, see, I wanted to ask this too. Did my court date the other day get streamed?
The audio did.
So people heard my court date the other day?
Yes, but the court date from the day before is still missing.
And so what you're saying is the court date that I got arrested at, you were able to record that?
I was, yes.
And the judge said you're allowed to. I'm telling you right now, I have a court order from the judge that says that anybody who listened to that live stream was allowed to record it and post it on YouTube.
Well,
Because
good.
the day before, okay, once you get the hearing from the day before, because remember the media hearing was the day before when I had to argue it, okay, and he said that we're going to live stream it. Because you know how I want to broadcast audio?
Yep.
The judge said, we'll broadcast audio, and anybody who wants can record it and do whatever they want with it to keep me out of it. See what I mean? That told me the judge already knows what's going on. Because Rachel's argument was that she didn't want me to be able to use 122H because this is why you got to get that recording. She argued that we put commentary on it. And she's talking about the chat, okay? So she goes up there and she goes, well, I don't want him to be able to live stream because he adds commentary. And the judge said, well, okay, I'll live stream, but I'm telling you right now, I can't stop people from recording it because once we broadcast it, people can do whatever they want with it. They can record it, they can post it, they can share it, they can do whatever they want with it because I'm the judge and I'm broadcasting it. See what I mean?
Yeah.
So the judge said, I give people permission to reproduce this and post it all over YouTube.
Well,
so make sure you recorded that.
Yeah, thank God he did that then.
So you're saying my hearing is available for people to listen to from the day I got arrested?
It is. Yep. I've encouraged everybody to download it and re-disseminate it as well.
And I'm telling you right now, you have a court order. The judge gave a court order saying that you guys can post that on YouTube. And you'll hear that when you get a copy of the hearing from the day before, where he says, Rachel, I can't stop people from recording this and broadcasting it. Once it leaves the courthouse, people can do whatever they want with it. That should be that was some food for thought for me, right? In my slap motion, right?
Yeah.
Well, if the judge in my case is saying, once it becomes a public record, there's nothing I can do to stop people from passing it out on YouTube. Well, that's 14 of my charges. So.
Yeah, and why does she so desperately want to operate in a secret court?
They want the videos off YouTube, which show things.
Well, they've been making complaints, and all it's done is it's made more and more and more and more and more.
Yeah, I don't encourage that, but people can do what they want, right?
That's
and
right.
So that's what the judge was saying. That's what the judge was saying. He told the prosecutor, because she didn't want people to, she goes, well, I don't want it on YouTube. And the judge says, well, I'm going to broadcast it, and people can put it on YouTube.
Yeah, he literally broadcasted it on YouTube.
Do you get what I'm saying here? He said, Rachel, I'm going to broadcast it on YouTube. And this is my judge for these charges. And you think I'm going to plead guilty to a felony?
Well, hopefully we can.
My judge already told Rachel, I'm recording and putting it. The judge said once we put it on YouTube, it's public. That should be writing on the wall to me, right?
Yep. And to her.
If I got four felony counts for paying $35 to order a recording of a transcript and posting it on YouTube, and the judge is saying, you know what? Hey, the judge gave you it for free, didn't he?
That's right, he did. Save me some money.
Who? Me? Me? I don't take meds. Oh, okay. I only get my fingerprint for my sugar. My low blood sugar. I seen that, but what were we saying? Are you telling people how to set this app up and shit?
I am, yeah.
Hey, but hear me out, right? The judge, the prosecutor goes, Your Honor, I don't want him to be able to record because it'll end up on YouTube. And the judge says, well, I'm going to put it on YouTube, Rachel, and there's nothing you can do about it. And then she wants to charge me the crime for putting it on YouTube.
In fact, you're being charged with crimes for putting things on YouTube.
Yes. The judge can put the hearing on YouTube, but I can't.
Do you think she's going to charge the judge?
She should just keep charging me with new charges. And that's what I'm saying. At some point, we just got to say, okay, like, it's like, okay, well, I guess we'll find out in court, won't we? Because and if a judge tells you you can't wear a blue shirt and you wear a blue shirt, you didn't break the law. You know what I mean? You just broke the judge's order.
That's right. You just wore a blue shirt.
Wearing a blue shirt is not a crime. So what they're saying is what I've done is not a crime, except because it was against the judge's order. Well, the judge can't tell me I can't wear a blue shirt. And then if I wear a blue shirt, they can put criminal charges on me. You get what I'm saying here?
Loud and clear.
I'm sitting in jail. There's freaky people coming to the house.
That's sick, man. It's depraved.
But I told him from the beginning, I'm the one to do this to because I will not crack. I might look like a dumbass and lose everything. Lose my wife, lose my dogs, lose my fucking life, everything I have. Be back at ground zero. But I think that if I didn't, I wouldn't be able to. I mean, somebody's lying. Somebody's lying here. The law or Rachel? Because Rachel, I know you're listening, Rachel. I know you're listening, Rachel. Let's read some of the grand jury lies. And thank you for everybody that sent money and shit. If you're sending it to Venmo, I don't know how it's going to get to my wife without her going to my phone, which is fine. I don't have nothing to hide. But she already didn't like a couple of me telling a few of the YouTubers that I love them. A couple of my mods, I said I love you too and shit. It's all good. It's private. Our relationship is private, but I'm just saying, like, I don't have no skeletons. I'm not cheating on my wife, so I'm not worried. But, let's see. Let me give you one that I can even say without giving myself another charge. My godfather says, alright, I really need you to get this. I need you to talk to Parvin about what you can post and what not about it. You know what I mean? Because it's public record for sure. It's filed. It's definitely filed. It says filed.
I'll get with him in the morning.
I'm charged for that. I want to shit like that, right? Let's see. Channel went on your YouTube channel on October 18th. Might be live on YouTube. And apparently somebody received calls with threatening tone. But I don't know you could be charged with threatening tone. I thought you could only be charged with threats.
Threatening tone, huh?
Threatening tone. A threatening tone by people that were not me.
Wow.
Voicemails from other people calling names, and they were in a threatening tone. In one of my calls, it says that I said, no one is trying to hurt you. They just want information. And I'm supposed to be worried about the jury hearing that?
Yep, I remember the exact quote. No one wants to hurt you.
No one wants to hurt you. They just want information.
Yep.
And I'm supposed to plead guilty to a felony to avoid the jury hearing how I said nobody wants to hurt you? They just want information? Are these people fucking sick in the head?
They are. They're pure evil.
I'm facing so much time that I have a 12-man jury instead of an 8. And they couldn't even get the grand jury to agree that I threatened their life. So how are they going to, by law, they're allowed to say anything they want to the grand jury and not get in trouble. They can lie and not have, it's like they can lie and it's not, they can't get in trouble. Because I still get to fucking fight what they said, you know what I mean? It's not like they can go in there and lie and you're convicted. Lie and you get charged. See what I mean?
I do.
So she went in there and lied and I got charged. But she didn't go in there and lie and get me convicted. So now I get to go in there and I get to question those allegations. You know what I'm saying? Dispute those allegations. And you know, the grand jury even asked, did he ever go to her residence or home? No, he's never physically gone to her residence. So people have gone to my residence, blew my window out, and went there when I was in jail to harass my wife. Are they getting taken in front of the grand jury?
I don't think so.
I don't think so. Well, there was a witness, a secret witness they won't talk about. Put the name of the witness. So there's a secret witness that they quote.
What's the quote from the witness?
The victim has been, or at least advised me that she's been very intimidated and in fear for her safety and the safety of her family due to the actions of the defendant. That's what the witness said. I don't know who the witness is, but that's just quoting the witness word for word.
Oh.
The bailiff responded, okay. The foreperson said, any other questions for this witness? The next person asked, did he ever go to her residence or home? No, he's never been physically gone to her residence. Okay. Any other questions? Did you state that there were voicemails from other people leaving messages? Yes. Through a lot of these videos, the defendant has encouraged other folks to contact her and contact her employer. I've never, ever made a video saying to contact anyone. But I don't want to get in trouble for, I don't care. I mean, it is what it is. If they have to, what are they going to do? Show this call to the jury where I was reading the testimony? I didn't say her name. But, it's like, what, I'm supposed to just imagine being an American citizen who's not even allowed to talk about what's happening. Shouldn't the First Amendment be the most important when you have something that's happening like this to you and you need to tell the whole world? Isn't that the point of the First Amendment? Hey, this crazy shit is happening to me. I need everybody to know about it. But somehow, me telling the whole world this crazy shit that is happening to me keeps getting me more charges.
It's Orwellian.
And my wife was reading 1984 the day I got arrested. Like, she had just bought it and was reading it, the day I got arrested.
Jeez.
I saw it on her book thing. She came and I saw Orwell 1984. And so, I mean, what is the cost of freedom? Freedom is not free, but who pays for it? If freedom's not free, who's going to pay for it? I'm a political prisoner in Russia right now. You know what I mean? At least, remember the basketball player that got taken in Russia? At least he got caught with a vape, right? Well, I'm sitting in jail as a political prisoner. No crime, no bond, freedom of speech. They take away my right to talk about it. If I talk about what's happening to me, I get more charges. If I get more charges, I have to stay in jail longer. You know what I'm saying? It's like, how is this the United States of America? It's not, because in Pima County, and that's why people really need to go after Laura Conover's public messaging, where she talks about if she doesn't like a law, she just won't follow it. She literally says that she doesn't follow the Supreme Court because she doesn't agree with it. She made a public post saying, "I don't agree with what the Supreme Court that said, and I'm not going to be following that law." And then people wonder why I'm sitting in here right now talking on this stupid thing away from my wife and family because of these videos. While other people there's people that have made death threats against me and nobody's even done anything about them. But for me, if I were to do the same thing, it would come back on me as a charge.
Yeah, absolutely.
I did notice that in the release conditions, they used the word alleged victim this time.
Jesus.
At least the piece of paper from the court says alleged victim. Not convicted of. Yeah, so, and I was supposed to go to court in New Mexico tomorrow.
Yep. Were you able to do something on?
No. Not really. Because I didn't know I was getting arrested that day, but I told Kent knows. It doesn't matter, because in that case, we all know what happened to.
Yeah, we do.
The whole world saw what Moreno did and the judge, right? So if Moreno can do that to me, Kent Walquist can prosecute, and the judge doesn't follow the law, what the fuck are we even doing? How can a court be considered legitimate? Like, how can you be considered legitimate court if you hang up on my motions? The whole world knows what happened. The whole world knows that if you were to grant my motion, you'd have to get that Kent Walquist created Brady violations.
Yep, you'd have to hold him accountable.
Get away with it. But he's allowed to get away with it because the judge hung up on the hearing.
Because of a third party. This is another third party thing.
Yeah, in Arizona you can't be convicted for third party.
Yeah, what is that? LaFaro versus Keshel.
Right, that's all this shit where they refer to indirect contact. Well, explain to me what indirect contact is, because if I don't contact you, it's not direct. If I didn't contact you, I don't understand indirect contact because it's not a legal term. It's a made-up thing that they made up. There's no such thing as indirect contact. Now, there might be if you say, I said this, tell this person I said this or something, but I've never done that. Ever. And so, I just really think that when you're sitting here and your wife is fucking really mad at you, and you can get out today, tomorrow, if you plead guilty, I mean, it's like, she said, just get out of there and come home. You know what I mean?
I wish it was that easy.
Because jail's not a good place for anybody, right?
No.
I'm saying, what can we even do?
We can be louder. We gotta be louder, man.
Right. We gotta be louder, man. Like the black guy that got beat up in Phoenix, that case got dismissed because of public, right? The guy that was deaf or whatever, and they beat him up. Civil rights lawyer did a thing for that and shit.
Yeah.
And it's like, I'm telling you right now, these people aren't very smart if they're not fighting for me, they're not fighting for themselves.
Nope, that's a point I've driven home.
I was literally getting ready to leave on a week vacation with my wife, and we checked the mail before I left, and it said I had 14 felonies and had to appear on. You have to sit down. And now a week later, I'm in jail for the next 6 months. That's how fast my life changed. I was fixing a window that got blown out the same day I got the fucking thing saying I had to go to court on Friday. That's how fast this shit comes at you. But they know that's all they have is jail. I'm not facing the death penalty. But if I plead guilty, that's life. You know what I'm saying? At what point did the dude say, give me liberty or give me YouTube?
Right. I mean, we can't even get any accountability. All we can do is some exposure.
Right. Right. I mean, there can be accountability. People need to get a hold of the Attorney General. They're all friends, though. They're friends. They take selfies together. Laura and the Attorney General are besties. I really believe in my slap motion. And you said you recorded my court date, right?
I did.
How fast can you pull it up? Did you hear the part where the judge said we might be making some history?
I do. I do remember that part.
Why would the judge say that?
Because he knows. He knows. He read that whole thing before that hearing, bro. How are you going to start reading that and then just be like, oh, well, I'll get to the rest later. This is unimportant.
No, that's not even what he said, though. I mean, he was being serious because I emailed it on the way to court. That's what I'm saying. Like, he literally was being serious. He said I've only been had like 25 minutes to look at it, right? And that's true. Remember, I was on the way to court and I said the motion to exceed page limits got denied?
Yeah.
By the clerk. But did you notice the judge started the hearing by saying, I'm granting your motion to exceed?
I do remember that. It gave me great joy.
The first thing he said at the hearing was, I'm granting your motion to exceed the page limits, which means he wanted to be able to read the whole thing. And his first point of business was, I'm making your slap motion official. It's over the page limits. That's okay. I'm granting you the page limits, and I'm granting you, and it's filed because then he said I'm allowed to email his clerk or whatever, right? And here's something I've never thought I'd ever hear a judge say in my entire life. What did he say next? He said, I'm going to read it over the weekend.
No, he said, I'll have it done by week's end.
Oh, is that what he said?
Yeah, which gives it even more urgency in my mind.
No, I think he said, I'm gonna read it over the weekend.
We'll dissect it while you're meditating.
I'm pretty sure he did say that, when he said, I only had 25 minutes to look at it, and I'm gonna read it over the weekend. I asked him about, when is he gonna make it? Then I asked him about, when is he gonna decide on it and shit, and he said probably by the week's end.
I trust your memory over mine.
I hope. Because I was there. But I mean, I'm not, he might have, but I'm saying I was like, I know he did because he goes, I'm going to read it. He goes, I only had 20 minutes or whatever to read it, but I'm going to finish. He goes, I'm going to sit down with it over the weekend. And then I was like, okay, and when do you think you're going to decide, when, and to tell him or something? He goes, I think I can have that by the week's end because that's when my hearing is. I have a hearing on Friday also with the judge that I already have the judge. You know what I mean?
Yep.
This shit here is not. My hearing tomorrow is a judge they brought in to keep me in jail. The next hearing, we're gonna try to get with my judge, but if not, it'll be another judge that just is there for one day, right? Remember the first time I got arraigned, she's like, I'm not your judge, I'm just doing this today, right?
Yep.
Well, in the next 20, so I'm gonna be in here at least 20 days, and that's gonna put me over the first of the month and having to pay bills, which means I have to figure out a way to tell my wife how to log into my shit and do all that shit. And so that's why people really need to my house or my Congress politicians, and it's not even that. And if they don't do nothing, we can use that against them later. See what I'm saying?
All right. Well, we'll overwhelm them.
Are you telling people to email you so you can forward it on to the proper authorities?
I am.
Are you doing that?
I am.
Because I know they're listening. I know they're looking. They don't expect them to just. That's not how those people work. They don't just tell you what they're doing. They don't respond. But it isn't like you're blocked. You know what I'm saying?
I do know what you're saying.
And it's a paper trail, right? It's a paper trail. So later on, I can say, where were you when I needed help? If you don't help. It's like the people that were reporting the gymnastics thing. They got like $800 million from the Department of Justice because they reported all that shit to the FBI, and the FBI didn't do nothing about it. So here we are reporting all this shit to the FBI, right? And we have to, and it's like, then we have a paper trail. So that's all I want is a paper trail for later to say, we told the whole world what was going on, and nobody, and either people helped me or they didn't. And these are the people that knew about it, and they either did it, or they either helped me or they didn't. Because that's all we can really do, right?
Yep.
And that's the thing is like, it's like, you know, people can send messages of support to my wife too, because she doesn't understand what I'm doing this for. She doesn't truly understand the whole like thing that I'm standing up for, because she would just rather go ride our bikes and stay off the internet. And I probably would too at some point, but I need to know that there's still somewhere that the law matters.
And I appreciate that more than I can convey to you.
Every single YouTuber on YouTube should be donating to my legal fund and backing me up, because if they convict me, then that makes case law that they can use against them. Just like Lane Myers makes case law saying people have the right to go to the park and be left the fuck alone. I'm trying to make case law that says we can be YouTube and left the fuck alone. See what I'm saying?
Yes, sir.
So that's why people need to understand that this isn't just supporting Lane Myers, they're supporting themselves, because they might get something in the mail one day.
And they might not be able to zealously advocate for their own defense like Lane can.
They might not be able to file a 43-page slap motion and knowing you're going to go to jail in a few days while still trying to put a new window in. I still had to put a new window in while trying to fucking fill out and now there's people showing up at my house.
Did I lose you? I can't believe we just had an hour-long jail conversation. Are you still there? Alright, I'm going to let the phone hang up on me rather than hang up on him. Alright, well, there you have it, everybody. Live from the Pima County Detention Center. That was...
Thank you for using GTL.
What was that?
Who, in general, and posts. Okay, I want to address the Phoenix Times. There is a website called the Phoenix Times. It basically links to other news articles and posts press releases. I couldn't find any Joey Payne associated with that. And our public affairs representative indicated that the person here today is from RP Media, which is a different company. So I'm not at all certain who's actually making the request. And without that, I'm going to have a hard time to stream this. So, Mr. Parvin, I'll start with you first. Your position on this.
Well, my position is, again, we've already ruled because there's no victims, or the court ruled because no victims here, there are less concerns. There's no objection to streaming. I think the court already prohibited Mr. Myers from using his own personal device today. under the understanding that others would be able to do it that would not have as much of an interest, I guess, in the case. Mr. Myers was allowed to speak on his behalf, even though I have not officially withdrawn yet. Could the court let Mr. Myers answer this question?
Okay,
personally?
Mr. Myers, do you want to answer this?
The question, yes. Phoenix Times is a DBA. It's just a website name to, you know what I mean, do.
Yeah, it's owned by, hold on, it's owned by Newsmatics Inc., is that correct?
It's
In Washington, D.C.?
You pay them to host the website.
Okay,
That's who hosts the website.
okay,
It's just to do ads and stuff so that you have a website people can go to and stuff like that. And because it's out of Phoenix, they had a local guy. It's just like having an independent contractor.
okay, but I don't really know who this is, and I evaluate
You mean who's here today or in
Who-
general?
in general, who the Phoenix Times, I don't, I have to evaluate.
Media company.
It's your media
I
company?
own Freedom Productions LLC.
Okay,
One of my
and,
DBAs.
all right, so this is your company, basically.
It's a DBA, but it's not an LLC.
Okay,
You don't have to have it registered to use it. It's so that we have.
but your company, basically, opened this website as the Phoenix Times?
My company, Freedom Productions,
Yeah,
which is multiple companies under it, started that website so people had a website to go to, and we could sell ads so that we could have the email Phoenix Times and all that. In exchange for that, that company puts you out there, and then they run those ads on there, and they get ad revenue.
okay, all right, let me,
We do the stories and that kind of thing, but it's just like it's like a website hosting thing. You know what I'm trying to say? You pay them to market you.
all right, let me hear from the state. Ms. Stiles, your position?
So who do we have here today?
Somebody who says they're from RP Media, which my understanding is a contractor that has been contacted by by somebody to cover this. The Phoenix Times is not an entity. My understanding is just a website that the defendant opened.
Well, the rule's just very clear that there has to be that notice given to the court prior to. So if we're getting somebody else who's filming who didn't provide the notice to the court, they wouldn't be entitled. We're still live streaming, so the recording's still being put out in the public. But if this isn't the person who requested, this company isn't the one that requested the permission, then I think under the rule they're automatically denied. It's my understanding from the rule.
I'm going to reverse my ruling from yesterday. This is not what I thought I was approving, and I find it very confusing.
Can I say one last thing, sir?
Yeah.
Even though I'm not to persuade you to overturn it, but just to clarify something.
Make your record.
Yes.
Go ahead.
Okay. Is there a better way you want us to file that in the future? Because it's ultimately Freedom Productions doesn't have its own website to give you.
Okay. You can file something. I'm not going to give you legal advice. I just did not understand who was making the request, and it was very confusing to me. And I'm concerned about the nature of the charges in this being a harassment case, about who's doing what. So I'm not going to allow. I'm going to deny that for today's hearing.
Can I say something, Your Honor?
Yeah, hold on. There were a couple of things I had on my list here before we.
Okay, but I wanted to add to that could change the prior ruling, maybe the reason
Okay.
for as well. Your Honor, we still believe that under the 122H, Mr. Myers should at least be able to use his personal audio recorder to record the hearing for his own purpose. I think that's what the rule permits. The reason we didn't object more at the last hearing is because the court was going to allow a separate company to essentially film this. We would have concentrated more on that objection and perhaps Mr. Myers would have filed more on why 122H would allow him to do audio recording today. That's a concern because the only reason we accepted the court's ruling without further argument, or Mr. Myers would have filed more motions, was that he understood the court was going to allow some sort of video today. I don't know what YouTube is showing, or I don't know where it's being live streamed, how people can access. I'm just not familiar with it. But I think Mr. Myers at least would like to use his personal recorder 122H to give notice about it and be able to record this hearing.
I deny that. So let's. One thing I want to do quickly so I don't forget is Mr. Myers filed a motion to exceed the page limit, which I'm granting. And that's for his anti-SLAPP motion. So
Thank you, sir.
you didn't have an order, so I just want to do that on the record. All right. Next, before we address the defendant's motion to represent himself, Mr. Parvin, you wanted to say something.
Yes, it's come to my attention that rather than file all charges at once, where Mr. Myers would, I guess, be bailable as a matter of right, This whole situation seems to be piecemeal filing. There are Tucson Police Department officers, I don't know if they're in this room now or if they're waiting outside, ready to arrest Mr. Myers on new charges that will be consolidated with this court, which will therefore deprive Mr. Myers opportunity to respond and represent him pro se, therefore forcing me to be on this case against Mr. Myers' wishes to represent himself. I ask that we be, if the state seems to know what's coming, that since this court has jurisdiction for these new charges, I ask that we do an initial appearance today immediately and set release conditions so that Mr. Myers can continue to represent himself, because otherwise we're going to have a real problem after this court grants this motion, because now he needs new attorney on the new initial appearance. And then I'm back in this with the same kind of Feretta motion doing this again. We got a real problem, Your Honor.
Well, so we have a CR pending now. Defendant's been held over, and I'm going to rule on that. I don't know what's going to happen if they're going to file an amended indictment, if there's an arrest and they want to go forward on an amended indictment. That there's nothing pending that I could. I understand your issue, but there's nothing there's nothing pending that I could address.
Well, I wonder if the state has any information at all, because considering there's an arrest, that he's going to get arrested on new charges. I just talked to the officers, so that's kind of it's going to pose a real problem here. How is Mr. Myers going to respond to motions pro se? At the same time, how am I going to be withdrawn? He needs representation. And then if there are new charges on new arraignment, the court's going to have to reappoint me again and do this all over again. So again, does the state have any information of all? Because I mean, these officers seem to have information.
Ms. Stiles?
Your Honor, I notified defense counsel yesterday that there were likely new charges coming.
Okay.
And so this defendant just happens to be committing new offenses. And so he faces, just like anybody else who would be ongoing criminal activity would be facing new charges. That's the position he's in. And
let me ask this. If that occurs and it proceeds and there's an indictment on the new charges, would that be in this CR or a new CR?
it would be a new CR.
Okay.
As a chat
That would be
room.
assigned to me, because typically we assign all matters to the same Superior Court judge.
Happy that we got to get a call with Lane and get a sense of kind of where he's at.
So, but those aren't pending. Would you agree with me that there's nothing I can take action on with respect to that? It's speculative.
There's nothing that he would have to go through the process, but there's nothing currently that would be in front of the court for the court to be able to do anything on.
But the new charges wouldn't affect these pending charges, correct?
Correct.
Okay.
It would, Your Honor, because it's going to affect potentially his bail eligibility, and that's a problem if there's no basis for the new charges. That's the whole point of Mr.
Yeah, I don't
Myers'
know that it
motion
was
now.
feedback. I'll have to go back and listen. I think it
would've
was
filed it slightly
mostly
differently. Maybe I
noise
would have
coming
done a
from the
motion to
jail.
dismiss under the or motion to remand once the grand jury transfer comes in. There are things I would have done differently, Mr. Myers, and I would have taken more time to do it. That's the reason I have to withdraw, so Mr. Myers can.
I send him
what he
little
wants, and he may or may
positive
not be,
messages.
right or wrong, doing it different than me.
Right.
Mostly
But that's a real
Victor
problem
Frankl
because
stuff.
If I don't know where the officers are, they work here. I don't know if they're in here now, can give information. But if this court proceeding concludes, we go out there and Mr. Myers gets arrested, brought into custody. He needs a new initial appearance. I don't know when that's going to be. Obviously, the court's going to need back in on it. Are we going to have to reappoint me again and then go through a new withdrawal?
Keep perspective.
I'm wondering, at this point.
But I think that his worries are legitimate. I think that they're rational, right? So, to the degree that we can help him, I hope that we can kind of be there for him. Did I pin it? Yeah, I pinned it. We'll have a pretty long live tomorrow. Reaching out to people.
I'm just trying to think for.
Well, we could do a couple things. We could put off your motion if you'd like to withdraw. I mean, that would be the.
But then my
He needs his motions filed. Sorry.
Hold on. The court system goes in steps, and we're at one step right now. I don't know if he's going to be charged in a new case or not. I have no information on that. But if you would, if you in consulting with your client would prefer to stay on now, and then we could reset this, or we can go forward. That's your choice.
I think what's going to happen, as procedurally crazy as this will be, we'll proceed today with the motion to withdraw and Mr. Myers' request proceed pro se. My understanding is all of his motions have been filed, which will prompt the state needing to respond, and that way at least everything's filed. And
What up, Nico
I'm
and
guessing
Sai?
I will be notified of the new initial appearance. Now again, I have a calendar as well of my other OCAT cases, and I'll have to rearrange things to try to come to the new initial appearance. I'm guessing I'll be appointed again, and then whatever new case is, we'll have to be right back here on the new case and do this again. I guess it needs to be done twice, from what the court's understanding is. But we'll do this today. We'll get through it, and Mr. Myers, I will be with you. We'll talk to the officers and find out what's going on before you are arrested.
Yeah, I think that, again, we have to concern ourselves with what is currently pending, and I can't speculate as to the different steps in the criminal process, and I don't get the case back until the defendant is held over if there's a new case. So.
Sylvia, Sassy.
So I think
this is just a very unusual case.
They did this on purpose.
Hold on. I'm just explaining to the court why this. I understand everything the court's saying. I just hope the court understands how rare this type of situation is.
It's unusual, but people actually pick up new charges all the time. It's kind of a.
But I haven't done anything.
I understand, but I'm saying it's unusual where a person wants to represent themselves and respond to motions, but normally I should say the same attorney can help them while they're in custody.
They're doing this so I can't type at my computer. They just want me away from my computer.
Okay, all right. I'm not. That's not our issue today. Today our issue is whether you want to represent yourself. So, and I know the last thing I wanted to mention is that, Mr. Myers, I understand that when you're filing things through our e-filing system, that you're having a hard time marking action for a copy to go to chambers, and we checked on that, and there is only one filing system, and it is possible to mark action by the division. So
I don't know where that is on there.
Mr.
I even called the clerk and went over it on the screen with her.
Mr. Parvin, have you tried to go over that with him? Just show him how it works.
On the filing system, honestly, I've had some issues there as well, where even if it gets there, it goes to a pile. I find it much easier just to deliver directly to the clerk with the courtesy copy, because I know then there's a response that's been received. You don't always know it's been received if you use the action online, but I believe, I understand the court will understand if it doesn't get to them, there's a reason you tried. I don't think the court's going to hold that against you, Mr. Myers.
The only thing I could see on there is it says emergency judicial action.
You don't need that.
Right.
There is a way to do it. It's just always, I should say, more complicated.
I don't know if it's because I'm pro se and they won't let me.
So the answer to that question is that he was appointed, but there's more to it than and I can't get into it. But Parvin is a good attorney, and he's helping Lane. So it's not like it's not the typical thing that you're picturing. I think that he's got somebody that's being as zealous an advocate as you can be for a personality like Lane. So I think he's a good one.
Send things directly.
No, it's only one system.
Well, it won't matter now because they're going to arrest me and play games.
Mr. Parvin, what would you? I wouldn't. If you have problems with the system, how do you do it?
Well, it's not that I've had I've never had problems filing anything.
Right.
I've had problems where it thinks it sent it to someone, but it doesn't. Maybe it gets it's just on someone's desk, or doesn't get printed out, or it's in a list of documents. So I find it best, although as the attorney, it's easier for me to just follow up with for example, the state or the chambers and say, did you get this? And sometimes I say, could you please email me a copy? And that way I have it. But I understand Mr. Myers' situation. It's a little different. I think it'd be best to use the system where it gets to your court at some point. And if the court does not have it, I informed Mr. Myers it's still filed on time, and then the court would just explain, okay, it's not going to use that against Mr. Myers simply because it finally got to you at a later time.
So the issue that, I mean, it's important that we get copies. What I don't want is for Mr. Myers to email us all this stuff that's not just a document.
That's why.
If we don't get a copy, we don't know it's
matter.
filed. We don't keep it running. We don't look at every case all the time. Right. We take action because something's served on us.
He's the best.
And that is the problem I've had before when I thought I didn't follow up and I thought it was served on court and it wasn't. Again, it was easily fixable just because we just got an extension of time limits. But I understand Mr. Myers' concerns. That does happen sometimes where you never know for sure if the person receives it. You don't get confirmation.
I've contacted 2 of those.
So I'm going to amend my order from yesterday, Robert, that Mr. Myers can provide a courtesy copy. When you email me, Mr. Myers, you also have to copy the state prosecutors, okay?
I didn't reach out to the ACLU.
Right. I feel like this hearing is
Hold on.
I mean,
we're just talking about procedures.
But I know I'm going to get arrested when I walk out, and they're going to try to hide me from my computer. So I can't even.
You're going to get a new hearing on that.
How am I going to be able to even file anything in this case if I'm in jail?
I don't have any jurisdiction on that. We're talking about this case and what we're doing today.
I don't. You know what's going on. You saw the slap. It's going to be a slap in the next one.
The court's not going to read everything in 30 seconds. It takes time.
Mr. Myers, we're talking about procedures in this case, okay? I'm trying to help you so that you can represent. Hold on. So you can represent yourself. Hold on. You don't talk over me.
I'm not apologizing. Go ahead.
I'm just trying to find a procedure so that you can file things properly, so that I get notice. But I don't want to hear. I don't want to hear the arguments and the invective towards the other side.
I don't.
So I will amend my order that when you file something, you could email the state's attorneys, Ms. Files. All right. So you can't. You should never email something to a judge without the opposing party knowing about it.
Talking about like when you add the names? CC,
yes.
Right? Okay.
CC, yes.
And I'll suggest, Mr. Myers, no commentary. What I do, you simply add the motion. You say, this is what the motion is in the body. That's it.
Right. Then we'll make sure we have it. But I don't want, you've added a lot of stuff in the motions that.
Yeah, because this is all a BS case.
Okay, but it's not proper. I can only consider what's filed in the court file.
I understand what you're saying, 100%.
All right. So, are we ready to proceed to the defendant's motion to represent himself?
Yes, Your Honor. Mr. Myers, you have filed everything, right? So even if you're brought to custody, you have nothing else to file at this point.
As to the motion to represent yourself.
You're talking about the motion to represent myself.
Right.
I filed the notice of appearance with you. That's what we're
having.
I'm
saying even your slap motion's filed. Everything's
filed. My
filed.
slap motion's filed, but I had other stuff, Rule 15 and all that, but they knew what they were doing. This is dirty tricks.
I think everything's filed, Your Honor, where we could proceed.
All right.
That way you're not harmed.
My thing is if you let...
Hold on, Mr. Myers.
You were saying that initially a few minutes ago that, there was an option of, waiting a little bit to see, because, they might pull more tricks out of their sleeve. So the thing is that in order to make sure that I have an attorney, but my thing is I'm loath to do that because I want the slap motion heard immediately. So if I don't go pro se right now, that would delay you being able to act on the slap. You know what I mean?
Correct.
But it's also knowing that you left the house today with your wife's car half fixed, and now I got to go to jail. You know what I mean? And my wife can't get to work as an attorney in town because this is the level they want to take it to. I don't know. You know what I'm saying? What's gonna?
Okay.
I have a suggestion. Hold on.
Now I have serious concerns about these people being unethical.
Your Honor, I will accept the appointment on the new charges, considering the fact it'll be a separate case number that will address that. That way I'll be appointed on the new case if you're brought to custody.
Will it be brought in?
Still, eventually. And then we'll do this again on the second case.
So, yeah, there are no new charges pending.
Yes, there are. They're waiting in the hallway.
Hold on.
No.
You'll get an immediate court date on that.
There's a process. If you get arrested, then there'll be charges filed. They'll take it to the grand jury. If there's a true bill,
well, how would
it's the one where they got 10 days to get the grand jury? Okay.
So there's the new charges are not. They're not before me.
They're gonna arrest me when I walk out.
It's not before me.
But then I'm gonna go to jail and I won't be able to talk to you.
I was hoping it was already filed, like some sort of indictment. That wasn't the case. That's why I brought it up. Unfortunately, it's not yet filed, which means you have to go through the process, which I believe I told you about 10 days.
My car's sitting out there.
Okay. We're here on
Why
the
can't
waiver.
we be respectful and professional?
I'm trying to be.
No, not me and you. These over.
We're not talking about that.
We are though, because you know that as soon as I walk over here, and then I'm not. How am I going to be able to respond? If you say if you need further briefing in the slap or something, and I can't do it, then I'm screwed.
No, it doesn't work that way. If you're in custody and can't respond, we'll give you additional time. We won't work that way. I'm not going to. No, it doesn't work that way. You're not going to be prejudiced in this case because you've been arrested on new charges. Okay?
Yeah, they're gonna say that I committed a felony while I'm felony for a bond for,
That's different.
for making a meme.
That's different. That's different than your slap motion. All right.
Well, I'm gonna put a new one on the next one.
Okay, you can do that if there's new charges filed. That's not what we're here for today. Let's
Well,
really.
I'm scared that if I give up my right now, I won't be able to have it in the next case.
Have you right to rep attorney?
Yeah.
No, it's a separate case. I accept it. I'll accept the appointment on the new
So you get a new attorney in the new case, and then you can waive your right to that attorney,
Okay.
and you can file a slap motion in that case.
So there'll be CR over here, CR over here,
Correct.
judge whatever, judge or you maybe you.
Same
Okay,
judge.
so it'll be 14 over here, whatever the new over
Again,
here.
my understanding is the concern was I'm not ready to file a slap motion. I don't know if it's proper or not. It sounds like there is some merit, but I would have done it differently, and which means if I stay on this case, technically the court has to say it goes through me. That's why I'm withdrawing so that your motion will be filed.
That's what I'm trying to say.
Okay. All right. So, Mr. Myers, I can have you stand and be sworn by the clerk first. Then I'm going to ask you some questions about your waiver of right to counsel.
You solemnly swear to speak the truth, the whole truth, and nothing but the truth, so help you God.
Yes, sir.
All right. Have a seat. Mr. Myers, I'm going to ask you a bunch of questions, okay? And it's just the rules I have to follow before I can make a decision to allow you to represent yourself. And they're very standard questions.
Okay.
And it's from Criminal Rule 6.1, okay? So, do you read and understand English?
Yes, sir.
What's the highest grade you finished in school?
12th.
Graduated high school?
Well, I have a
GD?
no, I have a college diploma and 2 technical degrees, a paralegal degree that I got in prison.
Okay. Are you under the influence of any drugs, alcohol, or medication?
Right now?
Yes.
No.
Have you ever been diagnosed with a serious mental illness?
No.
You have the right to counsel for all stages of the proceedings, including appeal. And if you cannot afford counsel, you have the right to a court-appointed lawyer at little or no cost to you. Do you understand that?
Yeah, so I can go back to a lawyer.
Correct.
Right.
If I allow you to waive your right to an attorney, do you understand that you can change your mind and request to have an attorney represent you going forward?
Thank you.
Is that yes?
Anytime moving forward later on, I can go for myself for a little while and then say, you know what, I want a lawyer.
Right.
Motion?
Yeah, you would file, or you could just say in court.
Okay.
All right. So, do you understand you have that right?
Yes.
All right. Next, I want to talk to you about the risks of self-representation. First of all, I want to go over the charges. So, you've been held over for trial on an indictment that was filed on March 7th, and there are 14 counts to that indictment. Counts 1 through 6 are each Class 5 felonies. If the state can prove that you've been convicted of a prior offense, it takes you out of first-time offender status and makes you a Category 1
Is
offender,
Torque still in
which
the
means you're
chat?
not eligible for probation. So if you're
Torque, where
convicted,
you at?
prison only. Each one, the mitigated range is a quarter of a year, that's 3 months, and the aggravated range is, on count 1 is a quarter of a year to 2 years.
I
That's a
can't
Class
fix
6,
it. I
and then
don't
the
know.
others are all Class 5s.
There's something going on. I messed up my
Counts
settings,
2
John.
through 6,
I
where
can't make it
the
longer.
sentencing range is a half
all the
year
way
to
up.
2.5 years.
It's all the way up.
And then counts
Torque, I just read your
7
email.
through 13 are Class 1 misdemeanors, no prison available, there is probation available, or I could sentence you to 6 months on each. And as to all these, some of them may have to run at the same time, but some can run one after the other. So you're facing a substantial amount of prison. And then the last count, count 14, the stalking is a Class 3 felony. Again, if you're a Category 1 offender, the sentencing range is prison only 2 to 8.75 years. So you're easily looking at the possibility of a long time in the Department of Corrections. Do you understand that?
Can I say something back?
I want to know if you understand that.
Yeah, that's why I wanted to clarify something you said right at the beginning of that little section. About the felonies prior.
Okay. And you're under oath, and anything you say can be used
I know,
against
I was
you.
wondering if you meant, do they have to be in Arizona?
No.
Okay. Yes,
They
I
have to
understand.
be within a certain time period.
Yeah,
though.
they're
That-
26 years
Hold
old.
on. There is a way to strike it, but that's down the road.
Okay.
Okay.
So to answer the question corresponding to that little segment, yes, I understand.
Okay.
It sounded good when I talked
Now,
right into
if
the
you
microphone.
do represent
probably
yourself-
like I'm supposed to.
You'll be held to the same standard as lawyers. Do you understand that?
Yes, sir.
And you, I believe you have a paralegal degree, you said? But you understand that your lawyer, Mr. Parvin, has attended and graduated from law school and has practiced as a lawyer for a long period of time. Do you understand that?
Yeah, my wife was a judicial law clerk for 8 years too, till they got her fired in this case.
Okay, so what I'm saying is, if you're represented by a lawyer, you'd be represented by someone who went to school for a long period of time and has practiced for a long period of time in this area and has a lot of knowledge and wisdom and experience that he can bring to bear in representing you that you're just simply not going to have by not being a lawyer. Do you understand that?
Yeah.
Terrified. They're terrified.
All right. If you represent yourself, you'll have to do certain things like pick a jury. Have you ever picked a jury before?
Yes, sir.
You have? Okay.
And I won the case.
All right. You have to
John,
make
we
opening,
had
closing statements.
we had Lane on
And
the
you'll have
phone
to
for about an hour
cross-examine
earlier.
the state's witnesses
If you didn't
and
catch
examine
that
your own
towards the
witnesses. Do you
beginning of
understand
the
that?
live.
Yes.
And you may find it difficult to make arguments to the court. Again, if you watch your lawyer do it, he's very professional and smooth, and it may be harder for you to do that than it is for him to do that. Do you understand that?
And sassy. That's exactly right. John, this is because of all the singing that John does for us. Every video John comes on and he begins with a little ditty. Well, today it's John's day. So everyone, if you could please join me. Happy birthday to you. Happy birthday to you. Happy birthday, legend John Felix. Happy birthday to you. Happy birthday, John.
Yeah.
I do. You can go to school for 10 years and still not have ethics, though.
Okay, but that's not the question before us today. The question is training and experience. And what I'm trying to tell you is that if you represent yourself, you're giving up a resource of someone who's very trained in this area. Now, currently you're out of custody, and I understand that maybe you'll be in custody. If you're in custody, as the case proceeds, it's much harder to prepare your case
Obviously.
than it would be for your lawyer to prepare your case. Do you understand that?
I do, and that's why I'm trying to figure out why couldn't they just do this all at once?
Okay. And things that are hard to do would be to subpoena witnesses,
Because
review
they're
disclosure,
dirty,
and interview witnesses. Do
dirty
you understand that?
motherfuckers.
Although we will make provisions to try to make that as clear as possible. It is just more difficult if you're in custody. Do you understand that?
Yeah, I understand the game.
It may be harder for you to file papers in court. Today, we've talked a little bit about the difficulty, and we're trying to mitigate that, but you understand it may be difficult to file papers in court as compared to your lawyer who does it all the time.
File with court, you mean if I'm in jail?
No, just generally, just being
You mean throughout the litigation?
yeah,
when
just
I'm-
being a pro se person,
Yeah.
it may be harder for you to do it
Get
than
them in and stuff, right?
all right. And then when you represent yourself, you're going to have to stand up and argue to the jury, and in your presentation, you may have less credibility than the lawyer would have. Do you understand that?
Not in this case, but yes.
All right. Well, do you think? I'm just telling you that's a possibility.
I
I'm not.
understand the optics. Yes.
All right.
That's what you mean, right? The optics of it.
Yes, exactly. The services of an attorney can be of great value in determining whether the charges against you are sufficient as a matter of law, whether the procedures used in investigating the charges and obtaining evidence against you is lawful, including the lawfulness of any search, seizure, or police questioning. If an act you may have committed actually amounts to the crime for which it's charged, or if you have another valid defense of the charges,
Can
or if
end
you're
it
found
right
guilty, whether
now,
you should
too.
be placed on probation, required to pay a fine, or sentenced to a term of incarceration, and whether appellate review could be justified. Do you understand that? That services of attorney can be of great value in determining those matters?
I do, and if it gets past the slap motion, you never know. I might have to get one.
Okay. And as we've gone over, if you're found guilty of the offenses charged, that you do face the possibility of being sentenced to a term of incarceration, even though you've given up your right to an attorney. Do you understand that?
Yes, sir.
Having gone over the risks of self-representation, is it your choice today that you still wish to waive your right to an attorney in this matter?
In this matter.
In this matter,
Right.
this CR matter?
Not whatever they're going to do out there.
Correct, this case, this
Yes.
pending before us. And the answer is that is yes?
Yes, sir.
Has anyone promised you anything if you waive your right to an attorney and decide to represent yourself?
No, sir.
Has anyone forced you or threatened you in any way to waive your right to an attorney and decide to represent yourself?
No, sir.
Have you had the opportunity to discuss your decision to waive your right to an attorney with the attorney that's currently representing you?
I have. We didn't know this was coming, though.
Okay, but again, do you think you need to talk to your attorney more before you decide to waive your right
Not
to a
in
lawyer?
this case.
Okay,
I have one concern, Your Honor.
Sure.
Is the slap motion can be done any time, and that's the only concern I had. I didn't really feel comfortable filing that. What has a time limit that I'm worried about is a remand to the grand jury. I don't know when the transcript's coming in. That is a motion I would strongly recommend looking into filing. I don't know if Mr. Myers is capable of filing that motion in custody or even knows when he'll get it, but that's a strict time limit that really can't be waived by the court, although you can get extensions. I know how to do that. Mr. Myers may or may not know how to do that. That's my only concern. But again, I'm not going to file that slap motion. That's Mr. Myers'
Pima
motion.
County
That's
Superior
why
Court.
I need to be withdrawn. I don't know if there's a way to appoint me as advisory counsel
Come
and
on
give me
now.
permission just for that one basis to look into the grand jury and file that one motion only.
well, if I grant his motion, I'm going to appoint you as advisory
As
counsel.
advisory, can I still file that motion on his
Well, hold
behalf?
on, no, because then you're his lawyer. Hold on. What's the deadline for filing a motion for remand is based on what date?
So it's 45 days after they receive the certified transcript, so.
Okay. And you haven't received that yet?
I'm not, but I'm worried Mr. Myers in custody would not know how to do that. I would. That's my main
Okay.
concern with this.
I could extend that to 60 days. Ms. Alves, do you have any objection to that?
No, and like I said, I don't know when the transcript's going to be ready, but they still.
Okay. All right.
We're not up against that timeline, so if they need more time even than that, we can always keep
Yeah.
adjusting it.
So for today,
But can he file it, or does it have to be me?
It has to be you.
It has to be me.
But I will buy you time. I'm giving you time. Sorry.
yeah, okay. So what we're going to do is today I'm going to enter an order, and I am ordering that the defendant has 60 days to file a motion to remand once the defendant received a certified copy of the transcript of the grand jury. So that's 60 days. If we're bumping up next to that, then Mr. Myers, you'll have to ask for additional time, okay? What?
If I'm in jail and they mail it to my house, I mean, how would I even know I got it?
Don't you,
Send me
don't,
copies, even though advisory.
So the clerk's office sends out the copies, but we'll make sure that he gets it.
Okay.
He'll get access to all his
yeah,
disclosure.
if you're advisory counsel, I believe you
You're so
continue to
ethical.
I
receive.
get notice of court dates. I don't know what the rules of disclosure are for that.
Okay,
So we will make sure that Mr. Parvin also has a copy of everything, so he gets everything so that he can go and discuss it with his client. So even though Mr. Myers is representing himself, he has his advisory counsel, so we make sure that we're still sitting things.
Hopefully I can get the transcripts. They are available, is what Lane said. So they are available. But at the same time, I find it a bit of a stretch that Parvin's going to share disclosure with me.
Through Mr. Parvin.
okay.
But that's not really representing myself.
Well, do you not want me?
Well, no, I'm
you have the
saying-
right. You could get me off. If you want
I'm
me,
just
you
trying to
can.
make
The
sure that, like, if
Constitution, you
they're
mean?
going to send stuff
Yeah.
to him, is that what then he gets it to me?
Yes.
We need a constitution for the Constitution.
So,
He's your advisory counsel. He'll still be able to communicate with
but
you.
I'll also get sent a copy, right?
You should, correct.
It's going to send to both, is my understanding.
Yeah, there may be, if depending on his custody status, there may be different things with the media, but like we work with that all the time with people who are in.
So TC, the SLAP in Arizona was expanded in 2022 to include criminal prosecutions, and to my knowledge, it's only been argued successfully one other time, and that was the Trump electors case out of Maricopa County. So if you just Google Trump electors case, I think you'll see it there. That's why this is so huge. Now Michael's right. we have the Constitution. You would think that would be good enough, but apparently they had to carve out a specific law in Arizona, 12-751, ARS 12-751, to protect your rights. And I mean, it's obvious that doesn't even protect your rights, because he's sitting in jail right now. So I mean, the lunacy of all of it, really, if you think about it. Oh yeah, the Constitution's supposed to protect us, supposed to protect this thing, but where are we at?
Custody representing themselves.
Okay.
So he will have access to everything.
The next thing is,
You hear that, right?
Yeah.
You heard what they said?
Yes.
Yeah, they're dirty.
Mr. Myers, to waive your right to counsel under the rule, you also have to sign this notice of waiver. So Leah,
What did Lane do? That's a good question. You would think that he murdered somebody.
you hand that to him? And it's on page 2 that you sign it, and I sign it as well, and then it gets filed with the clerk.
Do you want?
All right. The defendant, Mr. Myers, has signed the notice of right to waiver of counsel in open court. We'll put that date on there. The date is the 20th. Court makes a finding that after discussing the matter with the defendant and having observed his demeanor, that he has knowingly, intelligently, and involuntarily waived his right to counsel. The court will appoint Mr. Parvin as advisory counsel, and then we will talk about the schedule here. So there's that. That gets filed in open court. And
Your Honor, I don't mean to interrupt. I just got a text message. Someone mentioned they can't hear any audio on the broadcast. I just want to make sure this whole thing was recorded with audio.
yeah, it says it's streaming active.
Okay, I'm not
So,
sure why I was sent that text message, but it's just what I was told.
okay.
Just can't hear any audio on the broadcast.
All right. Let's look at the schedule. So we have a motion to modify conditions of release scheduled for the 27th. And as to that, Ms. Stiles, I'd like, if you're going to present evidence at that, which I assume are videos, is that right?
That's correct.
Could you provide those copies to me beforehand so I can watch them beforehand, so we don't have to just sit and watch all of them? And then you're obviously going to disclose copies to the defendant as well, correct?
Yes, absolutely.
Okay.
Your Honor, how would I prepare for this in jail? You just told them to disclose all this. We went out. They could have told me this yesterday. They knew we were setting this hearing. They knew that I needed the evidence. We went over this yesterday. We made a big whole stink about making sure I had the disclosure so I could have due process ahead of the hearing. And now now I'm just being I was just appointed and under the understanding that, after this hearing today, they would provide it to me and I would go home and start getting, preparing for next week. Why they couldn't just bring this up at the next conditions of release hearing, you know what I'm saying? So that I could actually make cognizant arguments, because now they're just going to give you, it's like, I'm not even, the evidentiary hearing is a trial, is a hearing on the merits of their motion. Like, I don't even get to make arguments because they're going to put me in jail and avoid me. That was the whole point. I wanted you to order them to disclose it to me, and you said, well, we got time for that. Miss Stiles, make sure you disclose it to him so he has time to get ready for the hearing next week, right? So they're saying, so all of a sudden you just asked her right here in open court, Miss Stiles, I assume you're going to be showing me this, that, or whatever. Could you send it to me, right? So that implies to the court right now that they knew as of right now what they're going to send, or yesterday, or any of that, and they could have apprised me of this ahead of time, but they're waiting to right now to put me in jail, and then they're going to show you the evidence. I won't get to prepare for the hearing. I'll come there looking like a dumbass in a clown suit, and then not even, and then they'll be like, oh yeah, and I had no time to prepare, no time to argue, and my lawyer can't prepare because I just took him off the case. This was all a setup. They could have.
Okay. So, Mr. Myers, a couple things. First of all, if you're in custody next week, then there wouldn't be a need for a motion to modify conditions.
What are we doing?
And so we would put it off, or if you're not able to prepare for it and we're there, you can tell me that you've been unable to prepare for it. What the state said yesterday, though, was all the videos that they're going to use come from you, so you've actually seen the videos.
I don't, but that doesn't, sir, that's not process, that, so I'm supposed to assume which ones they're going to use? I don't know I make hundreds of videos. So that's like saying we're going to use something the color blue.
Okay.
That's not properly telling me. Now, if they're talking about for the whole case, like in the 14 counts, that's what I assume they meant. But if they're talking about specifically to prepare for the evidentiary hearing, and they're going to bring up videos there, they need to tell me, because those are different. Because remember now, this is a hearing for the conditions of release, which means things that happened after the indictment, right? So now I can see for the things in the indictment, absolutely I should know because I have the indictment and I could read it in the police reports and all that, right? But I'm not. But the conditions of release hearing are things that have happened since then. I haven't been indicted, or I haven't been. You get what I'm saying? Given disclosure specific to, because when they filed their motion to modify, they didn't include no exhibits, no nothing. There was just, hey, we just want you to take our word for it. Trust me, he did this. And so, and it was not even him, it was somebody else. And so what I'm saying is that how do I not for the indictment, which is like you said, you got time for that. Specific to this hearing, now they're going to put me in jail. And they could have. It seems like they know what they're going to present yesterday. Like she said in open court, it's going to be videos of me. Then she should have had no problem saying it's going to be the video that you made called this. It's going to be the video you made called this. It's going to be the video you made called this, or posted on this or that. No, videos. I got 586 videos.
Okay.
Which one?
So, Mr. Myers, at the hearing next week, if you have not been able to prepare for that hearing, we can put that hearing off. I don't have to decide it next week. So, do you understand?
May I respond?
Sure.
Your Honor, so we've already been sending out the paper disclosure that has the information about all the videos that we have. We also are preparing, I believe it's going out today if it hasn't already gone out to Mr. Parvin, but we're sending him out, and now Mr. Myers will make sure he has access of all the videos that we're referencing. I am also happy to provide a list that I can send to Mr. Myers that specifically identifies each video that we're going to be doing. So even though he produced them, we're absolutely disclosing them, which is required that we disclose those to him, and we are absolutely doing that. We just couldn't give them all, immediately because we have legal obligations to do redactions.
So, Mr. Myers, when we come back next Thursday, if you
guys catch that? Did you guys catch that? What did she just say? She's got legal obligations to do redactions in YouTube videos that Lane posted on his channel. Dumbest shit I've ever heard. This bitch is so stupid.
you think you haven't had a chance to prepare, we can always bump the hearing.
Yeah, because I've asked her 5 times for that, and she said she has it now. What, paper? She's mailing it to my house while I'm in jail? This is a game.
Okay.
I don't suppose the court has Friday available, so I can come too. I'm just trying to pick a date when I would have more time. As advisory counsel, Thursday is a really heavy schedule for me. If the court can do Friday on the 28th, I have an open schedule that day.
Well, the reason we said it yesterday is then we also had the victim's input, and Mr. Parvin was here. I don't understand what happened to the date since yesterday.
And I was withdrawn. Let's make it Mr. Myers needs me. I think the question is
advisory counsel, right?
Except advisory counsel, he should have been preparing to be there because advisory counsel should be at all the hearings.
We were, but we didn't know that. Now I'm going to go to jail today.
Okay, hold on. So you'd rather do the 28th than the 27th?
That way I don't know how long. It sounds like it's going to go longer than I expected. And the Friday, I have an open calendar where I can be here as long as it takes.
We still have 5 days notice for the victims.
I can text
Okay.
right now.
Is she going to contact the victims right now?
Yeah,
Okay.
she's going to reach out.
Yeah.
All right, let's wait for just a second on
I'd
that.
appreciate it. That way, if it does go 2 or 3 hours, I'm still available.
Okay.
I thought
Okay.
it'd be only a quick half an hour here.
Sounds like they'll make it work.
Okay. So we're gonna change the hearing on the state's motion to modify conditions of release from the 27th.
They were glued to the hearing.
And that will be from 2 to 4:30. I'll have set aside for that. Okay, so, and again, Mr. Myers, if we get there and you can explain to me why you're not ready to go, then we'll address that. And obviously, Ms. Stiles can respond to that as well. And your slap motion is pending before me right now.
So me getting arrested or anything won't. This case can work independently from them arresting me when I walk out.
Correct.
Because you need to see that, please. While I'm here, can I stand up for a second?
Sure.
You know, the slap motion isn't really something the criminal side of it isn't something that's really well defined yet. So like it's not really even in the rules of procedure. So I don't even know, is it going to be a standard 10-day? Because it's not even something they're required to respond to unless you order them to.
Correct.
So I don't know, is there a set period that you have to make your ruling?
60 days.
Before you order them whether to respond or not.
Oh, so I'll review it and I'll probably try to get it done this week. I mean, it just depends. And if I order them to respond, I'll do that fairly quickly.
Okay.
If I rule on it without making.
I'll review it. I'll probably get it done this week, I think, is what he said.
And I'll probably try to get it done this week. I mean.
That you have to make your ruling.
60 days.
Before you order them whether to respond or not.
Oh, so I'll review it and I'll probably try to get it done this week. I mean, it just depends. And if I order them to respond, I'll do that fairly quickly.
Okay.
If I rule on it without making them respond, I'll also get that out fairly quickly. So.
And also, my understanding is you can rule on it without an evidentiary hearing, or you can if you.
Correct. I could rule on it.
I would prefer to have one if you know what I mean.
All right.
Unless you feel, you know what I mean.
Well, I have to make that decision. I've started to look through it. It's pretty long, like 25 pages or something. So I haven't read the whole thing yet. Well, it's not your fault. I'm just saying, I started to look at it, but I haven't read, because you have a long paragraph as to each count.
Right. That's the only way I could do it. That's why I had to exceed, because it's like 15 pages for each count.
I'm not criticizing you.
79 to 80 page motion.
I'm not criticizing you. I'm just saying that it's going to take me a while to read it all and have to decide whether to order the state to respond or not. And I know, as you said, that it's new to include criminal actions in this anti-SLAPP, but it's there, and we'll address it. Okay, and that's what happens. Maybe you'll be making some new law here.
That's where I'm.
And we'll address it. Okay, and that's what happens. Maybe you'll be making some new law here.
That's what all this is about.
And that's what happens. Maybe you'll be making some new law here.
That's what all this is about, because I'm the only one being charged for these videos. There's 500 videos of the same person that nobody else is being charged with except me. There's video. So when I'm going to go here, I want you to hear this right on the record. I'm going to go to jail right now, and there's going to be more videos made in the next 24 hours about the victim than there has been made in her entire life. So I'll be sitting in jail, and there'll be 500 new videos about the victim. She's going to get 500 new emails,
Myers,
500 new memes made about her. How does that protect the victim? It doesn't. This is a charade.
Well, it may be.
You better charge every single person. And I want you to address this on the record, because you said this yesterday, and we kind of talked about it for a second.
Can you slow down, please? Slow down.
Slow down.
Slow down. I thought you said sit down. I apologize.
Slow down.
All right, so I would like to address this, something you said yesterday, because it's very pertinent as the matter. You're the trial judge, right? And so, you know, I don't know when I'll be able to get back to my computer to notice adjudicated fact, but you ordered me, not asked me, you ordered me yesterday to remove your email from public posting, right? Because Gina's email is not, you know what I mean? And so, but in the period of time that it was up, right, you did receive emails, right? We went over that, you know, and I mean, are those people going to be charged with crimes? You get what I'm saying? And so this is pertinent, and I want this on the record, because the judge in this case received emails as a state of Arizona employee at his .state.gov, and nobody's going to be charged for those emails with a crime by the same agency that's charging me for a crime for other people sending emails to some, not even emails I sent. So in this case, sir, will you be charging me with 14 felonies for those emails you received yesterday at Gina's email? Because that's what we're dealing with in this case. I didn't send the victim any emails. Other people did. I'm going to jail right now for something other people did. So in that case, when we come back on Friday, you should have there should be a felony for each email you received, right?
So let me tell you how it works. Do you understand the separation of powers?
I do.
Okay.
Craig, it's going to take less than 180 days because he's got speedy trial rights.
And do you understand who makes prosecutorial decisions? You understand that?
I,
Who makes prosecutorial decisions?
we're
Not
good.
me.
I know. But I'm saying, so I should expect to walk out there and get charged for all those emails you got.
I don't have any idea what they're.
Well, I mean, you would have reported them to the police.
I'm not going to tell you what I've done or not done. I don't charge people.
That's what I'm saying.
I hear cases.
You're appointed by the governor, right?
I'm a judicial branch employee,
That's what I'm
not
saying.
an executive
You're
branch.
not. What I mean is, over at like Justice Court, they get elected through votes.
Hold on. We have 3 branches of government. I'm in the judicial branch.
Right.
I report to the Supreme Court.
I understand.
The prosecutor is publicly elected. She's an executive branch official. Okay?
Right.
She does their thing. I do my thing. Different silos.
Right.
Okay?
And what I'm saying is you as a judicial officer of the state of Arizona, also people could make a video about you on there and say, oh, I don't think he wears nice shirts, or I don't like the ruling he made in that case, right? They're not going to get charged with a felony.
Okay.
But I am.
Right. Again, we're pending. We're addressing the charges pending before me in this case.
That's what I'm talking about. Because I'm being charged for things other people did.
All right.
That might be defenses, but we're just trying.
Yeah, we're not.
I just want to make sure. Because I want to tell my friends to get
the schedule, and I'll just affirm the case management conference of April 15th and the pretrial conference of May 16th, both at 9 a.m. You are ordered to be present at those hearings. If you're not present, then the court can issue a bench warrant for your arrest. Do you understand that, Mr. Myers?
I do, sir.
All right. Anything else we need to address today?
No, Your Honor.
Just that the court already said that in the event that jury trial does go, I don't think it will, that we would waive my presence that on the April 15th.
Oh, you mean the pretrial, the case management conference?
Right.
And if they need to reset the hearing, we'll be fine with that. We can always work with the dates as we get closer.
Okay.
I don't want
Yeah.
to reset it now because I don't think that trial's going to go. That's why I'd
Okay.
rather keep it.
Yeah.
Why did you say that though?
What?
Why do you say it won't go?
Because things always, a lot of times you get notification, may either get continued or settled before the actual jury trial date.
Yeah, I'm not giving up my.
I'm not talking you.
Different case. He's got a different case. Maybe he's got a conflict on that date, but he's saying that.
Talking about in this case, the trial might not go.
No. I was talking about a reason why it could probably still be available on the 15th. I'm not going to make continuance unless I know for sure.
In your case.
Right.
Okay, I thought you meant in this case.
Yeah. All right.
'Cause I don't want to continue anything.
I know you don't. That's why.
This shit should have never happened.
With that, we're adjourned and you're excused.
She's already crying about the last video I posted. Keep crying. If it comes down, 2 new videos come up. 2 new videos for everyone that comes down. Sorry, I was eating my dinner at midnight. Alright, so that's that. We got any questions before we sign off for the evening? There's a link to the Give Send Go. Who knows how many days he's gonna be there in the gulag. So if you guys have the ability and you're inclined, please help him out. More importantly, your calls and your emails, let's start focusing that towards the that's all. For tomorrow's live, I'll assemble a list of emails for his state reps, the attorney general, stuff like that. We'll get some new inboxes churning. Dirk, when did you send it? I've gotten a lot of emails in the last couple days. You just sent it at 8:31? Yes, I got it. Wow, Dirk. I think John's live stream got taken down, but don't worry, he's gonna upload it in a regular video, plus the one he did today. So 2 for 1. Yay! Thank you very much for that email. Let's do this. Let's put a little star on it. Let's mark as unread. That was potentially very exciting. So, all right. I hope, why can't they do it? I think that those are the only videos that they're actually not privacy striking, right? Because it doesn't help their case if his videos are taken down, right? Thank you very much. I thought so too, Clueless Beekeeping. I thought it was epic. Alright. I could chat back and forth with you guys for probably a long time. Maybe maybe that's it, Analysis Media. They're like, wow, this is like 7 hours long. We'll just leave it. Alright. This is a public service. I hope everyone has a great evening, and we'll, I don't know what time. Before the hearing at 2:30, so maybe, I don't know, maybe around 11, we'll do a little telethon, see if we can give some people a call. Yeah. I appreciate everybody, and hope everybody has a good night. And I've said that like 4 times, so get the fuck out of here. All right, later.